Hello and welcome to Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'll be joined by David Burton, a partner in our Labor, Employment, and Immigration section here at Mullen, to discuss new Virginia laws regarding worker classification. How are you doing today, David?
Doing great, Brydon. How about yourself?
Doing well. Thanks for coming on the Benefits Companion.
My pleasure. This is an important topic that's just evolved in Virginia and become effective as of July 1st.
Yeah, every summer we get some new legislation goes into effect in the Commonwealth, and this year, as you said, pretty important legislation for employers. So, what exactly are the new Virginia laws regarding worker classification?
On July 1st, the Virginia General Assembly's new statute 40.1-28.7:7 went into effect. And that statute is entitled Misclassification of Workers. You almost can consider us a mini California now on this topic. But what this statute does is it creates a presumption that if an individual is providing services to a business or to an entity, that they are going to be an employee, not an independent contractor, unless the company employer can establish that under the Internal Revenue Service guidelines as to the independent contractor test, that the individual that provides the services is actually an independent contractor. It shifts the burden to the employer to establish from the get-go that this individual is an independent contractor and not an employee.
So it's just a presumption now that if someone's performing services for a service recipient, that person is an employee in Virginia.
That's exactly right. Unlike other states that will give some deference to companies in evaluating that, Virginia now is going to say, prove to me why this person is not an employee.
And in my experience working with employers and sometimes with smaller employers, I think they assume that they can define whether someone is an employee or independent contractor on their own by an agreement. So they'll have an agreement that says this person is an independent contractor, but it really isn't what the employer or the service recipient calls a worker. It's whether they meet the test. So how does an employer know whether a worker is an employee or an independent contractor?
Well, under this statute, what the employer is going to have to do is evaluate the IRS independent contractor test. And that test is used in a lot of different capacities, but in this context, the employer will have to go and look at the test. Now, many people know the IRS independent contractor test is a 20-factor test. Those factors are still there, but the IRS a few years ago tried to distill it down a little bit and look at certain areas to determine whether somebody is an independent contractor or not. The factors, kind of think about it in three broad categories, the way the regulations are drafted now. But you look at behavioral control, financial control, and then the type of relationship between the entity and the individual. When you think about behavioral control, that's things looking at like, what instructions does the business give the worker? If the worker is subject to the business's instructions and rules on how they perform the service, they begin to look like an employee, not an independent contractor. The types of factors that the IRS will look at, and Virginia courts under this new statute, they'll look at, are you giving instructions to the individual on when and where to do the work? Are you giving them instruction on what tools or equipment to use? Are you providing those tools and equipment? Does the individual who's performing the job have the right to go and hire their own people to help out with the job, as opposed to the employer or the company providing its own employees to help that individual? Do you direct the individual where to purchase their supplies and services? And all those types of factors. If you have a lot of those factors and you check that box, that looks like behavioral control. When you think about financial control, Is the individual having their expenses, unreimbursed business expenses, paid by the company? How much does the individual employee have to invest in order to do the job? Does this worker offer these services to the outside market other than to just your company? How you are paying the individual. Are you paying them on an hourly basis, or are you saying here's a flat rate for you to perform this service? Can the individual employee realize a profit, or can the individual who is providing the services realize a profit or loss? Those are the financial controls that the IRS will look at. Finally, they'll look at the relationship. As you mentioned earlier, Brydon, just because you have a written independent contractor agreement doesn't necessarily make that individual an independent contractor. It's evidence of the party's intent, but you still have to go back and look at the behavioral controls and the financial controls to determine whether that is an effective independent contractor agreement. Are you providing the individual with employee-type benefits such as insurance, pension, vacation? If you have an independent contractor agreement that provides that you're going to give that individual employee benefits, they're an employee.
Right.
Don't think about that. Also, one of the last factors you kind of look at is what are the services that the individual is providing? If they are providing services that your other employees already provide, it makes it very difficult to argue that someone is an independent contractor. So if I could give an example of a company having a true independent contractor, the easy examples are people like Brydon and I. We're lawyers. We work for a law firm, and we are engaged by clients to do their work. We're not employees of the clients. We are true independent contractors, but towards that company. But if I am let's just use an example. If I am a assisted living facility and I have numerous certified nursing assistants working for me, and then I have other people performing the same duties, but I'm calling them independent contractors, that's probably not going to fly under the IRS test and in turn under this Virginia statute.
Right. And there are real consequences for misclassifying workers. And from the employee benefits context, there's a question as to whether somebody is an eligible employee under the terms of the plan. Under ERISA, the plan terms have the force of law. And so if your plan provides that a full-time employee or an employee is eligible for the retirement plan, 401k plan, elective deferrals, or health insurance, for example, if that person is an employee under this test, they have a very good argument they're entitled to benefits under ERISA. And it's really important for Affordable Care Act compliance, because whether you are an applicable large employer that has to offer health insurance is based on the number of employees, and then the employees that the ACA requires you to offer health insurance to are common law employees under these tests that David just described. So it's really important for employers to understand from a benefits perspective that classifying workers properly is really important. But David, what are some of the other consequences, outside of the benefits context for misclassifying a worker?
Oh, that's a great question, Brydon. And in fact, this new Virginia statute addresses that point directly. In the statute, the Virginia General Assembly has created a private right cause of action in Virginia courts for individuals who believe they have been wrongly classified as an independent contractor. And what that private right cause of action allows an employee to do is to go into court and try to recover an amount, any wages that they should have been paid instead of an independent contractor fee. If they were performing salaried duties, a salary, employment benefits, as you just mentioned, including, and this is very important, expenses incurred by the employee that would have otherwise been covered by insurance plans. So if an individual were to prove that they should have been classified as an employee as opposed to an independent contractor, and therefore they didn't have your company's healthcare benefits and they didn't have benefits anywhere else, and they had a surgery Let's say that surgery cost $100,000. The company who is now going to be deemed the employer will be responsible to reimburse the employee for that cost. In addition, the individual can get any other compensation that they should have received. Think about paid time off, all those types of things that employers offer to employees. And the thing that all employers hate, attorney's fees. If the plaintiff prevails, they get their attorney's fees. And there is not a shifting attorney's fees provision in this statute. So the company that has to defend against such a claim is not entitled under this statute to their attorney's fees. So this is a serious statute that has teeth, and companies are going to need to be cognizant of it and be very circumspect and work with lawyers to determine when they are classifying people as independent contractors, is that true? And what the danger is if you don't classify it.
Right. And so it seems that the employer should really presume that the people who are performing services for them are employees, and be very careful. Be very careful if you're going to take the position that they are not employees.
That's right. That's what the statute says. And the days of especially smaller companies classifying folks as independent contractors to save some expenses perhaps until they get on their feet, that's going to be a very difficult argument to make now.
Okay. Well, thank you so much for being on the Benefits Companion, and that'll wrap up our discussion about worker classification. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.